Great. So good morning, good afternoon, good evening, everyone. My name is Ishan Madan. I'm the founder of Arbitration and an international arbitration lawyer. Though the pic behind me shows that I'm in Manhattan, I'm currently hauled up in Florida. What makes this world of over 7 billion people across over 200 countries unique is diversity. There is diversity in leadership, trade, art, sports, and almost everywhere else. Abinsol, along with Arbitrator Intelligence and Dale Meda Pereira, are delighted to welcome you, all of you, to this very important and timely roundtable dialogue on diversity in international arbitration, broadening the scope, where we discuss the importance of many factors of diversity that affect legitimacy in international arbitration. We have today a wonderful set of speakers, diverse in their experience and outlook, to discuss the many important issues. First off, I would like to introduce my colleague and co-moderator, Kirsten Teo. Kirsten's profile is lengthy, but to keep it crisp, she's an international arbitration lawyer, a counsel at Dale Meda Pereira in Washington, D.C., the global lead ambassador of Arbitrator Intelligence. Now, over to you, Kirsten.
Thank you very much, Ishan. Well, without further ado, I will introduce Ishan. Ishan is an attorney admitted to the Court of India and also founder of Arbinsol, and is pending admission to the New York Bar. And it's my privilege to co-moderate and co-organize this with Ishan on such a timely topic. So I would like to first thank everyone joining us live now from 72 countries, our supporting organizations, and all the esteemed speakers for participating in this dialogue with us today. Your support matters. I would like to introduce some of the speakers today. We are pleased to have Professor Catherine Rogers. Catherine is a professor at law at Queen Mary, University of London, where she also co-directs the Institute of Ethics, Regulation, and Commercial Law. She's also currently a visiting professor at Bocconi University and is on leave from Penn State Law. Catherine is the founder and CEO of Arbitrator Intelligence, a legal tech startup that provides unique, quantifiable, and contextualized data analytics for arbitrator selection. We're also privileged to have with us today Rose Rameau, a visiting professor in arbitration, board member of Arbitral Women, and an arbitrator currently based in DC, who was recently appointed by Haiti at the Permanent Court of Arbitration. She's a barrister and solicitor of the Supreme Court of Ghana and an ICC court member on behalf of Haiti. Rose was awarded the ABA section of International Law 2020 Mayra Rasmussen Award for the advancement of women in international law. In addition, we are delighted to have Amanda Lee leveling the recruitment playing field so that law firms and organizations can hire the best people, regardless of gender, ethnicity, socioeconomic background, or geographic location. We are also happy to have Harut Samra. Harut is an arbitration associate at DLA Piper in Miami and is a board certified specialist in international law. He is chair of the Florida 3rd District Court of Appeal Judicial Nominating Commission, board member of the Chartered Institute of Arbitrators North American Branch, and director of the Miami International Arbitration Society, in short, MIAS. I now turn it over to Ishan to introduce our other speakers. Ishan, please.
You're muted, Ishan.
Yeah. We all say we should wear a t-shirt that says you're on mute. So to continue, we have with us Professor Dr. Patricia Shaughnessy, an international arbitrator. She's the founder of the ICAL LLM program at Stockholm University, and she's a former board member of the Arbitration Institute of the Stockholm Chamber of Commerce. I'm also very excited to be sharing the stage with Miami Law Hurricane, Sandra Friedrich, director and lecturer at the White and Case International Arbitration LLM at the University of Miami School of Law, and she's also a director at the Miami Law International Arbitration Institute. Last but not least, Christopher Campbell, who says he's currently at an undisclosed location. Chris is a very, very international lawyer who most of you would also know as the curator and the host of Tales of the Tribunal. Chris is also a visiting consultant at Baker Hughes in Italy. Now, before we move, just a suggestion, some housekeeping rules. You are all requested to please participate in this event, in this roundtable, through your questions and answers. I would request that instead of using the chat button, you use the Q&A tab for raising your questions, and the speakers will either address them on an ad hoc basis by replying to them, replying to your questions in writing, or we'll address those questions towards the end of the session. Also, from time to time during the event, some poll questions will pop up on your screen. To ensure that you can be unhesitatingly honest, the polling is anonymous and no one can see what you selected, not even us. And of course, this roundtable will have multiple rounds of discussions. It will be divided into 4 sections. Uh, First off, we'll start with the importance of diversity. So to speak on diversity, I first invite Professor Dr. Patricia Shaughnessy. Dr. Patricia, we are now in times where inequalities are emerging, and they're also being addressed, sometimes cursorily and often at grassroots levels. In an ever expanding network of international trade and arbitration, addressing diversity is an ongoing and unceasing task. But it is also very important to understand the very basic concept. Why and how is diversity important and essential in international arbitration? So I request you to please guide us on that.
Uh, well, thank you very much for allowing me to kick off. It's going to be a really interesting and lively discussion about diversity, as already pointed out, on all levels. And I've long been a champion of diversity, intellectual ability, motivation, the willingness and ability to contribute to the international community knows no national borders, and it should not. Our community must reflect and serve the international community across borders, across races, across religions, across backgrounds. So I think this webinar is one of the important aspects of increasing visibility and engagement and coming up with new ideas and solutions to actually move the needle. So let me briefly, very briefly, dive into the recently released ICA gender diversity report. And let me note, it's focused on gender, but today we're not stopping at gender. We're looking at the total, the matrix of diversity. The ICA report was a cross-institutional report, and those of you who have looked at it may note that it's very Eurocentric, although it did include ICDR, and it did include as well the Hong Kong International Arbitration Center, as well as the PCA and ICSID. And ICC, of course, is also rather global. And it could be criticized for not reaching out to a more geographic, and hopefully that will be done in the future, as it's just the first step in the studies that need to be done. The study had 3 main features, and that was first to scrutinize the existing efforts and approaches of the international arbitration community in the context of gender diversity. And let me just note as a footnote, ICA has another report, that task force report, that will be coming in the future, dealing with inclusion. A second aspect was to examine the data and trends, and that's why it was cross-institutional, in order to collect at least some years of consistent data that could be compared. And third, it wanted to provide concrete steps and suggestions that could move forward in improving the situation. And I think that we should focus a bit on those, because these steps that it finds and the recommendations could, to a large extent, be also applied to other types of diversity. And in the report, it has one section dealing on why it matters to care about diversity. And of course, that's because international law demands that. We need to do that to be part of a sustainable and a complying with international rules of law and expectations. It increases the functionality by increasing the talent pool and improving the outcomes that arbitration can offer. The report also looked at current trends, and the trends show that institutions have done a lot to move forward, but it's still lagging with party appointments and party engagement. On the good side, the trends show that things like the pledge and other initiatives, things like this webinar, actually can help to move forward in this important goal. The report also contains a section on the pipeline issues. What are the barriers? And some of those are equally applicable to other areas of inclusions, such as the barriers to entry, importantly, unconscious bias, harassment and bullying, aversion to new entrants, and just ignorance about the ways in which inclusion is being prevented. The fourth area of the report was dealing with opportunities. What are the ways in which we can find opportunities, which also connects with the last part of the report, the next steps. And arbitrator intelligence has a key part because one of the things that's identified is increased transparency will lead to greater diversity and will lead to accountability of institutions, of parties, of law firms, of everyone to actually be called out for, to be noticed for whether or not they're part of the problem or part of the solution. We all need to commit to do more. And a number of the things the report identifies, such as mentoring, requiring diversity, tracking it, all of these things I think we can use in part of our discussion today about how we can expand the things that the ICA diversity report finds in the gender space into other areas which are in great need of attention. So with that, 5 minutes, I wanted to keep it shorter. I'm passing it on.
Thank you, Dr. Shaughnessy. My next question actually goes out to Professor Catherine Rogers, and I invite you to kindly shed some light on diversity from a legal ethics lens.
Great. Thank you so much also for inviting me to this conference, which is already off to a great start. I'm going to be super quick because I know Chris is speaking next and I want to hear him. So let me just give a little bit of framework for the rest of our discussion. So there are a number of reasons we should care about diversity in the legal profession generally, and then I'll talk more about why there's a need, I think, in international arbitration specifically. So one of the reasons for a focus on diversity, both gender diversity, ethnic, racial diversity, is to correct historical biases. Both implicit biases, those cognitive biases that we all have and don't recognize that we're doing, and historical structures that prohibited literally groups from even going to law school for years and years until quite shockingly, relatively recent in the United States as well as other countries, minorities and women simply could not attend law school. So part of the focus on diversity is to rectify those historic biases that artificially suppressed the diversity in the legal community, which meant then also in the arbitration community. A second, I would say, one of the most important reasons to focus on diversity both in the legal profession and in international arbitration is representativeness. We are all in the business of providing justice. And justice relies not only on legal analysis and presentation of facts and evidence, but also perceived legitimacy and the actual legitimacy of the decision makers. And the representativeness, meaning that people who sit as the judges or the arbitrators have to in some ways reflect the diversity of the people for whom they're rendering justice. It's important to note that two of the most quickly growing regions in the world where international arbitration cases are expanding are Latin America and Africa. So that means what you have is a constantly increasing number of parties and counsel from Latin America and Africa, and the need for greater diversity among arbitrators is to make sure that those people involved in those disputes have people on the tribunals who look like them, who have backgrounds, cultural backgrounds and legal backgrounds similar to theirs, and that therefore both understand their in an individual case level, but also represent more collectively their presence in the community. The reason why this is even more important, I think, in international arbitration than it is in domestic national court systems is one, international arbitration expressly embraces and touts as one of its greatest strengths the fact that it's cross-cultural. You can't be cross-cultural, truly cross-cultural, and not be focused on and committed to diversity, number one. Number two, and I think this is something that's not often talked about, but relates to the topic I was given of ethics, so many of the practice of the ethical rules are developed for use in international arbitration aren't top down. They're not developed by some government and then passed on to the arbitration community. It means that we as a community come together to create these practice guidelines, these ethical rules, these ethical standards. And that means it's all the more important that the people who are drafting these new rules and standards are representative of the whole community, so that it is not just one particularly powerful subset of the community that is imposing its views on a intentionally multicultural, cross-cultural, and rich community that relies on, that strives to be diverse. It's sort of the tools and the outputs that it provides need to reflect that. I think there's also another reason why it's particularly important to focus on diversity, and that is simple, quality and meritocracy. There have been study after study that show that diversity among decision-making groups, such as, for example, panels of arbitrators or legal groups working on a case, that they benefit from a diversity of viewpoints. And that if you have everyone thinking essentially exactly the same way, we see lower quality decisions. Also, if you have essentially either latent or express obstacles for diverse lawyers to become active in the elite echelons of arbitration practice or as arbitrators, you are also, I think, transforming what should be the most robust meritocracy as arbitrators, because they are doing well, they're working hard. And if instead there's a lock on the becoming an arbitrator that includes or somehow hindered meritocratic components for getting into that position are hindered by latent biases that we have or other obstacles, just historic, then what we're doing is we're creating a class of arbitrators that are not the best they can be. So for those reasons, to eliminate bias, to make sure we have representativeness, and to have to ensure quality and a strong meritocracy. Those are all reasons we should all be concerned about diversity. Thank you.
Thank you so much, Professor Rogers. Now, let me invite the superstar from a Spotify near you, Chris Campbell. Chris, you're an in-house attorney, very active in international arbitration, and you have been closely following what one of the most influential hip-hop artists and rappers of all time, Jay-Z, has done for the arbitration community. Could you please shed some light on that?
Well, sure, and thank you for that great introduction, Ishan, and thank you, Catherine and Patricia, for kicking us off here. And I'm excited to hear what everyone else has to say. So you kind of teed it up there already. A couple of years ago, this guy Jay-Z, Beyonce's husband, needed an arbitrator, and he was unable to find an arbitrator that he felt could properly hear and decide his case. And in particular, one of those reasons was it was important to him to have someone that looked like him, a black person, not necessarily a black male, but a black person to hear his case. And that's something that he wanted. And he was struck when he received the list and there wasn't a single black candidate there to be appointed. And as I get ready to kind of talk about my feelings on it from my perspective, and I should note that my perspectives shared today are mine, solely my own, not speaking on behalf of my company. This panel, the folks that are speaking to you today, is diverse, but not because we are men and women and black and white and Asian and from Latin America and many areas in between. It's diverse because of what we bring to the table, the diversity of thought and the competencies that we bring. And what is often missed, to our detriment and to clients' detriment, the client's detriment, is the value that is represented, not in having someone that's just a different shade or a different gender or a different orientation, etc., but in having those different perspectives represented in resolving a case. The mindset of someone from Latin America might approach a legal dispute over a client matter 100% different or 180 degrees differently than someone from another part of the world. So I think that is one thing, and that's a primary thing that we must get right as we have this conversation about diversity and inclusion, is figuring out what in the world we're talking about in the first place. When I think of diversity and inclusion, I actually like to add a third thing in there as well, representation. Diversity being this idea of, are you in a minority category, so to speak? Inclusion being, okay, if you are there, are you actually being actively involved in a decision-making or capacity controlling endeavor? And then representation being, and this was a point brought up in this conversation from some of my colleagues, is does that representation make sense? You know, the example being, you know, someone that's in a remote province in China or India may not have a specific interest in employing a certain minority group from somewhere else in the world. So the thought being is that to the extent they are doing work with a given region, are they representing the diversity of thought from across that spectrum? Or are they just solely going with the majority? And that's what we should be certain to include. And so without, you know, dominating the time and certainly wanting to defer to the rest of the panelists here today, I would challenge those that are here and all those that are listening to consider 3 key categories in which we can be intentional, which is what I believe is required. And, you know, the onus does fall on us clients, so to speak, to kind of maybe kick the ball and get things rolling, are people, projects, and positions. People being, do you know somebody, or can you get to know someone or find somebody and help them discover their path into getting a better position? 2, can you work on a project that helps increase or make that endeavor better to increase diversity in a meaningful way? And 3, the positions in which you serve, whether it's a panel like this one, whether it is a co-chair position, whether it is as an arbitrator, what are you doing to advance the diversity, inclusion, and representation in each of those areas? I think the only way that we will see those things change, as we've seen in a number of areas, whether that be to gender diversity and representation or sexual orientation or any number of minority issues that we discuss, is if we're intentional and not just paying lip service to it, but laying out actual plans for how those things are going to change. And that would be my sort of opening start.
Thanks very much, Chris. I think that was quite a powerful start. Thanks a lot. So now, is diversity just about clicking diverse looking photographs, or is it fairness and giving equal opportunities, or much more? So I will now invite Kirsten to brainstorm through this over the next session.
Thank you very much, Ishan. I would like to invite the speakers in topic 2 as we discuss the broadening of the scope of diversity in international arbitration. So to kick this off, I'd like to invite Harut. Harut is an arbitration practitioner in Miami. And Harut, from your perspective, could you please share with us how your arbitration journey has been thus far, your experiences as a member of the various young arbitration practitioner groups, and perhaps shed some advice for law students and recent grads keen to enter the practice of international arbitration?
Fantastic. Thank you, Kirsten, and thank you, Ishan, as well, for organizing this really terrific panel. And I'm looking forward to engaging with the other panelists over the course of the next hour or so that we'll be discussing this, I think, very important subject, and certainly is an important topic of conversation in our practice all around the world right now. So part of what I wanted to say, and this I think refers back to some of what's been discussed before, including by Professor Rogers, including by Chris and Ishan, is that of course we have here a unique practice, a practice that in many ways differs from most of the other practices that our colleagues engage in, including the disputes colleagues that many of us work with in firms like mine or many of yours, and other settings such as academia and the others that are represented by this panel. I think this is in many ways a very global practice, and it's something that we have to keep an eye on always and keep in mind. We have all of these discussions, including the diversity discussion, but the diversity discussion, as Chris suggested, is one that is global in nature, and that is not necessarily going to resemble, or the discussion won't resemble itself really as you go around the world into the different regions where it is occurring. This is a multifaceted discussion. It is a three-dimensional discussion, and it is one that I think benefits from thinking about it three-dimensionally, as I think we are trying to do today. And one important element of that, Kirsten, is this broadening of the scope. It really is now a consideration of all of the ways that we can bring to bear the full diversity of the practice in its global dimension, right? And a couple of those elements we're going to be discussing over the next few minutes include things like age, nationality, practice backgrounds. Chris highlighted a number of them. People who have different professional and other backgrounds, different linguistic backgrounds. There are so many things that can be brought to bear when you consider the multinational quality that really distinguishes this practice from virtually any other that I can think of. There isn't another practice like this one. But in a lot of ways, that is a very positive thing. In other ways, we have to consider that it is actually a rather small practice. As multinational, as global as it is, it is still comparatively much smaller than many other, frankly, practices that are the bread and butter of firms like mine and others, whether that's securities or antitrust, et cetera. The international arbitration practice is still a growing practice. In the decade or so that I've been doing it, it's changed dramatically, and that's one of the things that I'm going to want to touch on over the next few minutes. But I know that you've highlighted a couple of these, and I wanted to really focus on them as well. And those include age and nationality. As far as young practitioners, there's been an important change in the practice, really probably over the last 20 years. I think practice, starting as first-year lawyers as international arbitration practitioners. This is a very unique, really in the history of this practice phenomenon. It's something that probably comports more with some of the more established practices. But this is a practice that really only came into its own, and I would be interested in hearing from those who maybe have been doing it even longer than I have, in the last 30 or 40 years. And that makes it in many ways unique. Law firms, for the most part, I suspect, didn't really have these practices, or they were only coming into shape, really, apart from relatively few firms in the last 20 years. And that, I think, has changed the spectrum of practitioners. Instead of having established litigation practitioners or other corporate practitioners who then transitioned into an international arbitration practice later on in their careers, including frequently academics. A lot of the culture, I think, of our practice is based on the fact that many of the earliest arbitrators were very prominent international law scholars. And what does that do? It has made, I think, our practice also a more scholarly one than many other practices that you see. We're frequently asked by our colleagues, why do you publish so much? Well, it's an expectation in our practice. And I think it's an expectation in part of our practice because of its academic origin, its academic roots. We've never really transitioned or transformed our practice. The fact that you have young lawyers who are beginning their practices as international arbitration specialists has changed the field completely. And I think you've seen all of the institutions and organizations, including those that we are representing here, really try to engage those younger practitioners. It's changed the game entirely as it relates to younger lawyers. And I think as a result, you've seen the proliferation of organizations. Each institution has a young professionals organization, ICSID, ICC YAF, LCIA YAG, which I was involved in for many years, ICDR YNI. I mean, you can run down the line. I am currently working with a colleague, Jessica Marroquin, here in Miami to kick off a young group within the Miami International Arbitration Society. And that's something, again, that is occurring all around the world. But what that's resulted in as well is now an increased focus as well on younger arbitrators. And I think we're all seeing this. We're all seeing this. If you participate in any of these organizations, you know of a number of colleagues who had appointments relatively early on. And if you engage the institutions on this, they will tell you that they want that. They want to broaden the alternatives they have from an arbitrator appointment standpoint, especially as you consider the now increased use of emergency arbitration and other really accelerated alternatives, whether it's emergency arbitration or other fast-track alternatives. They're frequently looking to younger arbitrators to take some of those appointments because the more established arbitrators frequently don't have the bandwidth to take on a very high-intensity 2-week proceeding. And so I've been approached, and I'm sure others have, about considering applying and then pursuing these alternatives. And I encourage those who are in my position to do that. I think that that is a great opportunity. And as younger arbitrators become more established, they will become more appointed. I think of just a few names off the top of my head of people who I know have become really well established and fall into this younger cohort of arbitration practitioners who began their practices maybe a decade ago or a little bit more as international arbitration lawyers. The horizons have broadened for young lawyers in that sense. The other aspect of this is nationality. And as Kirsten and Ishan mentioned, my practice spans a number of regions, but has for many years been very focused on Latin America. And I think Professor Rogers referenced Africa and Latin America, and that's something that for me has always been a very interesting contrast in many ways, although they're really following to a degree, I think, the same trajectory. And I've had an opportunity to have considerable experience in Latin America and some experience as well in Africa, including a capacity building effort that my firm sponsored pro bono in Tanzania, where we went for a week to train a significant number of Tanzanian lawyers on international arbitration, which was frankly an area that they flagged for us as an area that they wanted to learn about. One thing we've seen is international arbitration, as the international arbitration practice has flourished in Latin America, and Professor Rogers has referenced this, and I think it's exactly on point. One thing I would add is that it's actually reached, I think, a level of maturity that's extraordinary within a limited period of time, probably just over 20 years. You could probably point to the ICSID arbitration boom with Argentina as maybe the starting point of this incredible flourishing of the arbitration practice in the region. Whereas firms in the region would previously link up with multinational firms to participate in these cases and to work on these cases, they now, I think, to a very large degree, handle them directly themselves. And we are seeing this happen all the time. And while in many cases they still do link up with multinational firms, particularly as it relates to London law or New York law issues, this is not the same competitive marketplace as it was 20 years ago, which was really a marketplace in which local firms collaborated with multinational firms. Increasingly, the local firms are competing with the multinational firms, and that, I think, speaks to the incredible diversity that has emerged from the region. It is organic. As these practitioners become more comfortable and accomplished in this area, they're taking their own cases, and in fact, they're appointing one another. And I think that you've seen this happen in Latin America. As I've said, I think Latin America, to a large degree, has matured as a market. And Africa, I think, is probably on the same path. I think it's probably somewhat, well, some period of years behind, and that's probably because of the explosion, really explosion is the word, of arbitration that took place in Latin America about 20 years ago. And all you have to do, and I'll end on this point, is attend one of the regional conferences. I've had the good fortune of attending regional arbitration conferences in Peru, in Brazil, in Costa Rica, and several jurisdictions really in the region. And you will be, I think, very pleasantly surprised. In Brazil, for example, I participated in a conference where there were several hundred Brazilian practitioners who were there to talk about the international arbitration practice in Brazil. This is an incredible regional area of practice growth. And I think from a multinational global standpoint, if we think about what this means to the diversity of the practice, I think we will be looking at a very different landscape. We already are, if you consider where we were 20 years ago, but looking forward, as Africa now really comes to market and the local firms take on more of their own cases, you will see, I think, even more change, and that speaks to much of what we're going to discuss and have been discussing so far. Thank you, Kirsten.
Thank you very much, Harout. Just a quick question from one of the attendees. How would you define young in terms of arbitrators? It's been very encouraging.
This is the million-dollar question. Every young organization that's being launched probably has weeks of debate over where they draw the line. There is no, I think, precise definition. Different organizations draw different lines. Some say 35, some say 40. Some focus on the years of practice. As we consider, for example, the fact that there are many second career lawyers. And so it varies. It varies, again, by jurisdiction and region. For example, in much of Latin America and much of the world, people become lawyers at a much younger age than they do, for example, in the United States. So I think it is a fluid sort of thing. But I will say, for the most part, it seems to me that organizations have settled on, there's a consensus around sort of under 40 as a line, but it is a varied thing. And when you're talking about arbitrators, under 40 arbitrators certainly are young. Over 40 arbitrators frequently are very young as well. So I think it is sort of an imprecise concept that you've seen different organizations try to tackle that in different ways.
Thank you very much, Harout. And so now I'm privileged to introduce Rose. I would also like to add that we do appreciate that arbitrators do not just comprise of lawyers, but also experts in other fields. I would just like to acknowledge that. And I'd also like to now invite Rose. Rose, I just wanted to ask, based on your vast career in international arbitration, what are some of your thoughts on the importance of having civil and common law training and a deep understanding of different cultural norms? I'm sure there are people in the audience who would also like to hear your advice. With those who might have some arbitration experience and are keen to get their first arbitrator appointment. I turn it over to you, Rose, and I'm happy to share screen if you'd like me to.
Thank you so much, Kirsten. First, I want to thank Ishan and Professor Rogers and Kirsten for putting together this wonderful panel. Look at us. Take a good look. We are so beautiful. And this is how international arbitration should really look like. And I'll say this, in putting this panel together, I wasn't there, but I'm sure it was intentional. So for me, when we're talking about diversity, we also have to be intentional. Professor Rogers earlier stated that when we're having working group, we need to have representation across the board. And if we do not have that, then we are going to miss in the diverse group of representation. So congratulations for being intentional this morning. I'm very proud to be part of this group. We are beautiful, and we can see in international arbitration itself, it's already diverse. But however, in looking at the practice, like Harold already mentioned, in Latin America, you see the diversity. Unfortunately, we cannot say that much about United States of America when it comes to Blacks. We cannot say the same thing for Africa. So I will keep my presentation very, very short in terms of what Kirsten wants me to discuss, which is the common law and civil law practice. And I'm privileged to have experience in both. And yes, when you do have a common law and civil law background, I think you have some advantage in international arbitration. Now, Kirsten, do you want to show my slides, or
Sure.
do you want me? Okay.
Sure, let me do that right now.
Okay. Next slide. So do I have, I don't know how to operate this. So you, okay, good.
I will operate it for you. No worries.
Okay, is this the second slide?
Yes, it is.
Yeah. Okay, common law and civil law legal tradition. The reason I picked these two, they are not the only legal tradition. There are many other traditions, but I speak to these two because I am in both common law and civil law. And also in looking at the tribunals through many years, we see that tribunals have adopted some kind of compromise of the common law and the civil, because that's the most common legal tradition. So the common law and civil law, we know they're very different in terms of how the disputes are commenced, developed, and presented. For instance, you would have the unfamiliar laws. In Africa, you could have customary law that's very specific to Africa. You can have different ideology, and you can have infrastructure. If the tribunal is not familiar to what's happening in Africa at all, that could be a serious burden in trying to determine certain issues. For instance, how goods are delivered, or how a piece of mail is delivered. And you can have also the cultural differences between councils on both sides and the tribunal. And of course, you have different languages and definitely different approach to dispute resolution. When I live in Ghana, I was very shocked to see we did have something called customary arbitration. So you may go into a country or a geographic area, you're thinking they don't know anything about arbitration at all. You may be surprised. They have something other than what we are used to in the Western world. So next slide, please. So we have to look at, for instance, in the common law, we know the Federal Rules of Civil Procedure, Rule 8, says to us, you start your complaint by providing a short and plain statement of the claim. The idea is that at common law jurisdiction, lawyers are expected to conduct discovery. Therefore, they don't need to go into details. Versus in the civil law, you under Book 1, Section 4, the Rules of Evidence, Article 9 says, each party must prove according to the law the facts necessary for the success of his claim. So basically, when you have a common law and a civil law lawyer, it's like night and day. The civil law will attach all the evidence to the claim. Meanwhile, the common law will give you just a little bit and say, wait, you ask it shall be given to you only if you're entitled to it. So it's a very polarized system. Next, please. So you have the disputes in terms of the discovery. So the common law attorney, of course, under the FRCP 26B1, you are expected to have a broad scope of discovery. That's what French lawyers would normally say, the fishing expedition. You're not going to get all in my business. And French laws, we are very private, privacy laws, and also confidentiality. Almost everything could be confidential. So it's a very difficult concept for some French lawyers when they see discovery coming into the United States. The civil law, they say, no way, we don't need discovery because we already provided to you. In fact, the principe contradictoire, which is basically the adversarial procedure under Article 14 through 17, it's unethical for a French lawyer not to provide you the document. And in the US, it's not unethical at all. I'm not gonna do your case for you, you ask. So it's, that's when you see in the discovery. And it's fun for the common law lawyer, and it's very annoying for the civil law lawyer. Next, please. All right, so how do we solve the conflict? And what we've seen happening through the years is that tribunal, we have a compromise. Tribunal have taken a neutral approach by adopting a hybrid system. So the tribunal will neither be a common law nor civil law. It will depend on counsels and the legal traditions that they want to adopt. And this is because, arbitration is contract based, and therefore it will allow the parties to design the process that they want the tribunal to follow. For instance, they may decide from a very early on to adopt the 2010 IBA rules on the taking of the evidence, which is soft law, but they can incorporate it either before the proceedings or while the proceeding is happening. And of course, they would have consented to it. Next, please, Kristen. And another thing you see in international arbitration, in terms of the production of the document, then in the US, you will have, like I said before, a broad scope. You fish, you can ask your tax return for the past 5 years. But in international arbitration, what we've seen, is the red fern schedule, which is basically a form that provides a request of disclosure with detailed reasons, and you support each request. So when you ask for something, you have to really show why you need it. International arbitration targets specific document requests that must show relevance, but need to be material to the outcome of the matter. So we're not going to allow you to go 5 or 10 or 15 years in somebody's business. You have to tell the tribunal, why do you think this matters? And the tribunal also, if you can't decide with opposing counsel which evidence should come in the red fern schedule, you will basically send it to the tribunal. The tribunal will decide. This is what the tribunal believes will help the tribunal make a decision in the matter. So relevance, materiality, that's what's important. But contrary to the federal rules of civil procedure, it doesn't need to be relevant. We just need to see it. And then after that, we can decide if it's going to come in or not. You can make your objection. So, but not in international arbitration. Next, please. And also for the witnesses, you don't have deposition, you don't have interrogatory, no surprises. Basically, you'll have the witness statements. They are attached to the pleadings, and the witness statements will be pursuant to the term of reference. And the statements are basically the direct examination. And then when you go to the cross-examination, if you must have cross-examination, it will be limited as to what the witness already put in the four corners of that document. You can't go outside of it. And with the expert witnesses in the common law, you see they would provide the testimony separately. With international arbitration, if you have two expert witnesses, we do something called the hot tubbing. You put them in front of each other and they go at it in the tub and they fight, and the tribunal will determine which position is more credible. Next, please. And so what is, I think Kristen wanted me to focus about the benefit of knowing both systems. And this is just my personal opinion. For me, because I know both civil law, common law, when I have a case, I can be more diverse. How I'm going to be more diverse? Because I can choose to appoint someone from the civil law jurisdiction or from the common law jurisdiction, because I understand both. Meanwhile, if you only understand one, you are, I think, more inclined to go with a tribunal you think would understand better your legal system. But me, I don't really care. Civil law, common law, I will look for basically the best arbitrator. And the second benefit, if you are an attorney and you are versed in both systems, you are likely to be fluent in more than one languages. And you can take cases in French, in Spanish, in Portuguese, and that's a very benefit. And also, when a client comes to you and the arbitration clause says the proceeding must be in French, okay, cool, I can do that. So in a sense, you become more diverse in international arbitration. And you also probably, like Howard mentioned earlier, you would probably understand more culture, more norms and customs, which really will get you more access in international arbitration. Next. All right, what's the diversity issue? African states have a high tendency to hire Western firms instead of Blacks or African firms. Western firms, on the other hand, they have a practice that's not yet so diverse, and some of the department barely have any Black people on the team. And then the white firms would go and appoint who they know. So you have this system where you have, for instance, in an investor state, investor is a foreigner who's going to hire a foreign firm. And then in African states, for some reason, don't believe too much in his own people, the local, they go straight in their outside firm. And then you see a serious imbalance. So when the tribunal issued the award, for instance, $9.6 billion against Nigeria, you're sitting there, you're wondering, oh, really? I wonder, white tribunal, white lawyers, Black states. So for me, it is so important to have, like we say in the United States, a jury of your own peers. Now, it doesn't mean that you need to be Black to handle Black cases. But if we look like today, like we look, Kristen, you know, beautiful, handsome Chris, beautiful Kristen, beautiful Rose, Professor Rogers, and then you have a tribunal looking like this, and then we issue our award for zillions dollars. So come and challenge that, saying that we were biased because we are not one, we were very diverse. So I think it's very, very important. Diversity for me is the catalyst that brings the best out of international arbitration. And it really makes the award look good. Next, please. The result, and I think I've talked about that, you have high awards and people complain. It doesn't mean that the tribunal was biased, but just the look of it. It just doesn't look good. And that's why I think Chris talked about the Jay-Z. Jay-Z says, I would like a jury of my own peer. I don't know, man. I don't see anybody who looks like me. At least one, something, okay? So next, please. That's it. I think that I will end there. That's my little contribution. I hope I didn't go over time. Thank you.
Thank you very much, Rose. So next up, I'd like to invite Mandy. Now, Mandy and I have had several discussions on many topics, one of which is the high fees payable to attend arbitration events. And in some part, technology has normalized the use of virtual events, and it helps to reduce barriers to entering the arbitration practice. Mandy, what are some of your thoughts on this issue and the wider issue of making arbitration more accessible to more segments of the society?
Well, firstly, thank you very much to our hosts and moderators for kindly inviting me to participate in today's discussion. Such an excellent group of friends and colleagues. It's always difficult to follow Rose. It's particularly difficult to follow Rose today, I think, after that presentation. Socioeconomic diversity is a multifaceted issue, and the challenges it presents differ greatly across the globe. I like to sort of take things back to first principles. Today's students are tomorrow's counsel and arbitrators, so the challenges that go back to the beginning of our legal studies can have a significant impact on who we appear before and with in the future, and whether they're truly representative of our community. So I'll start by talking a little bit about events, and then I'll talk a little bit more about some of the background challenges that influence the ability of lawyers whose socioeconomic backgrounds are perhaps less advantageous to prevail in our field. Now, we're all familiar with the cost of many events in our field. Quite a few of them are prohibitively expensive, to all save for those in major international firms with large marketing budgets. And when it comes to securing prestigious speaking slots at major arbitration conferences, which is of course one of the ways in which you get big ticket cases as counsel, and one of the ways in which you start getting appointed as arbitrator, because you can build your reputation. People see you speaking, they know that you can say things that make sense. If you can't afford to participate in those events because you simply don't come from a jurisdiction where the currency is as strong. So for example, if the conference attendance is in dollars or sterling, for example, or euros, and perhaps in your jurisdiction, those currencies would require you to sort of spend a couple of months' rent in order to participate in a conference, you're probably going to decide that advancing your career is not the primary consideration, and that's not right. How can we say we as a profession are truly diverse if we are putting financial barriers in place that prevent the people who are appearing before us at conferences from truly representing who we are as an international community? We talk about the concept of pay to play, and the impact of this practice on the profile of the delegates and the speakers that we see at our conferences is something that I think conference organizers really need to keep in mind. Now, as Chris emphasized, it's the benefit of having different perspectives that is being lost by excluding people from different socioeconomic backgrounds. So, from the perspective, for example, of students in developing and less developed countries, where the average monthly income for a qualified lawyer, not a student, of course, may be less, or in some places significantly less than $1,000 a month, obtaining an LLM or participating in other forms of postgraduate training in arbitration, particularly in the West, may simply seem like an unobtainable goal. And that is not due to lack of academic ability or interest, quite the contrary. But absent suitable scholarships or financial support from family and friends, the financial implications of pursuing such further qualifications may be a significant deterrent. And why does this matter when this comes to our field? Well, for a start, many internships at international firms carry with them the expectation of having secured an LLM or having particular additional certifications or qualifications. And if the price of success is significant debt with no guarantee of a job in the field at the end, many talented aspiring arbitration lawyers may decide this is simply too high a price to pay. An unpaid or poorly paid internship is a significant undertaking for anyone who does not have the financial support of family and friends, or the support of, for example, their employer letting them go on secondment for 6 months to somebody offering an unpaid internship, or if you don't have personal savings that you're prepared to deplete to advance your career. And the burden is particularly significant for our aspiring colleagues in developing and less developed countries. And again, this is not about the lack of ability. I'm sure we've all spoken to aspiring professionals from all over the world who've said, I've just got, a fantastic opportunity at a wonderful institution or firm, but I simply can't afford to take the place up. And this is a terrible loss of talent. We place emphasis on the importance of completing internships as a field. Many are unpaid, and those who do not have financial advantages are always going to face a greater struggle. And this, therefore, has a direct impact on who is actually able to secure these opportunities. The socioeconomic background can also have a significant bearing on issues as simple as whether or not you have a network on which you can draw when you're building your career, when you're trying to get appointments, when you're trying to establish your reputation as counsel. If you're the first person in your family to go to university, or the first person to become a lawyer, for example, you may not have contacts in the legal field. And this is likely to mean that you're going to lack mentors. You're going to lack sponsors. And these people can be so key to our professional progression. And these kind of support networks are particularly important in a field such as ours, where a lot of us know each other. I have the pleasure of appearing on this panel with a number of really good friends. We know each other. We're a community in international arbitration. So, my mom's bringing me a cup of tea. She's a special guest star on the webinar. Thank you,
She's a
Mom.
sweetheart.
She's fabulous. She's fabulous. I could obviously go on, but I'm conscious of time. And so I wanted to share these initial thoughts to simply try and encourage a further discussion about this topic, which, as Kirsten and as everybody who knows me will know, is one of my particular passion projects.
Yes.
So,
and I want to thank Amanda for everything you're doing. I think I speak for all the students who follow you on Careers in Arbitration, and thank you for your wonderful work. Thank you so much for your support. And please write to Amanda if you'd like to continue the conversation with her. And I'd like to thank everyone who participated in this discussion of topic 2. I'd like now to turn it to Ishan to introduce the third topic. Ishan, please.
Thank you, Kirsten, and thank you, Haru, thank you, Rose, and thank you, Amanda. I think that was quite a ride, and you all covered quite a lot of issues, of course, with the time limitation. But thanks specifically to Mandy. Mandy pointed out something which is very, very important, and those are issues which, of course, they can never really be considered by the ones who have to actually engage in the practice of arbitration, the arbitration users, councils, firms, tribunals, because these are background things that nobody gets to realize. And the cream lies in the West, let's be honest about that. And so going forward, I think one very important thing to understand is how academia is helping develop this stream of diversity. And one important thing that, again, Mandy said, what today's students are tomorrow's counsels and tomorrow's arbitrators. And of course, most of us who've undergone LLM programs or who are trying to expand our understanding of international arbitration, a lot depends on the kind of faculty we are surrounded with, on the kind of opportunities that we get during our education. So this third session is all about how academic pursuits, educational opportunities can advance diversity and break the barriers of entering the international arbitration practice. So first off, I'll invite Sandra. Sandra, again, as I mentioned, is a director and lecturer at the White & Case International Arbitration LLM program at Miami Law. And Sandra will talk about opportunities in arbitration. And Sandra, specifically, we can talk about opening the doors for gradual reformation through academic pursuits.
Hi, thank you, Sean. Thank you so much, everybody, for having invited me to be a part of this important discussion today. I wanted to start out by kind of laying the groundwork in terms of the representation of different groups in graduate programs today. I think today we all know that women, for example, enter law school and graduate law programs like LLM programs in arbitration, for example, basically in equal numbers with men, and sometimes even more. That hasn't always been the case, as we also know, but these days women go to law school and graduate programs in often even higher numbers than men. For example, we at Miami Law just admitted our entering class for this year, and it's 54% female, and that is not unusual. That's the picture basically almost every year for us. So that is a huge improvement over the last few decades, of course. However, we also know that even though women enter law school and graduate law school in equal numbers or even higher numbers than men, and they enter the legal profession, they are not represented in equal numbers in leadership positions across the field. And I think that academic programs like LLM programs can contribute to help increase the visibility and the reputation in the field of women, and with that can contribute to achieve better gender representation across all levels, including but not limited to arbitrator appointments. But I think in addition to gender, it's also important to talk about the importance of including different ethnic minorities, and especially individuals from countries and entire regions that are traditionally underrepresented in the international arbitration field. The field is often criticized as, and I'm borrowing this expression, but it's so fitting, as being male, pale, and stale. And I think that arbitration is a global field, and the practice, and with that, graduate law programs should reflect the world in the student body. So we should have students from all parts of the world, including Central and South America, including the often overlooked Caribbean region, including, of course, North and Sub-Saharan Africa, the Middle East, Eastern Europe, Central Asia, Southeast Asia. Those are all regions that I don't think are adequately represented in today's graduate programs. And in order to recruit students from such diverse backgrounds, in my personal experience, it's not enough to reach them and to convince them that doing a graduate program in arbitration, in our case, in a city like Miami, that's a good idea. That's, of course, the easy part, right? Many students think that would further their career goals, that would advance their career, give them important knowledge. So convincing students to enter a graduate program, that is not the difficult part. The difficult part is really for enabling students to be in a position to accept an offer of admission. And I think that's exactly what Mandy was talking about just a few minutes ago. So it's very important to support students from diverse backgrounds through scholarship support and through ongoing support through the graduate program. It's a reality that in many parts of the world, as Mandy said, the monthly income, even of lawyers, cannot fund LLM studies in some of the traditional centers for international arbitration, be that in certain parts of Europe, like London, Geneva, Paris, and of course also in the United States. The cost of living alone is often astronomical, and then you add to that the cost of traveling across the globe, the cost of sometimes moving your family, because not all students are single. Many of our students have spouses and children, so the logistical difficulties are quite significant. And then of course also the tuition. So it's unfortunately a reality that loan opportunities for graduate students in many countries are non-existent, because the concept of student debt is not a concept that's common in many countries. So with that, students are not necessarily able to receive a loan. Now, for the US, for example, if you come to the US as a foreign student, you're also going to find it very, very difficult to obtain a student loan, because loans are usually limited, and there's a few exceptions, but loans are usually limited to US citizens and green card holders. And that is not the average international student. So it makes it very difficult for students to fund their studies if they don't already have the means to do so. With that, I think it's important, if we want to have adequate representation for students from around the globe in our programs, as an institution, it's of course important that we dedicate sufficient scholarship support For example, we have a dedicated, one of our full tuition scholarships is in collaboration with Young ICA, so the Young Practitioners organization of ICA. And it's specifically meant for students that come from countries or regions that are underrepresented in the field and that are also under 40. So it's specifically meant for young practitioners from underrepresented regions. And I think that that is an important step. However, I also think that recruiting students from all around the world, giving them adequate scholarship support, that's only the beginning. I think that it's very important throughout the graduate studies to adequately support students and to take into account that students come from very, very different academic and social backgrounds, and that they often need more time, say, than the average American student who comes to do an LLM in this field, to kind of acclimate to a different academic environment, different expectations. For example, the use of technology. I myself am from Germany, and when I first came to the United States, I never brought a laptop to class. This is, of course, some years ago, but this was very, very common. Everybody in my LLM class, was using a laptop, and I really had to get used to that. So I think it's important to also provide adequate support to students who come from all corners of the globe, to make sure that we set them up for success in the program. So just simply bringing them to the program, I don't think is enough. And I think so with that is, of course, important to set out the expectations and to make sure that students understand that grades are very important. In my experience, grades are not important in the same way across countries. For example, my students from Brazil always tell me that while grades are important, it's much more important that you work during law school, and that you that this is how you get your job, and it's very much understood that you're going to dedicate a lot of time to that. So expectations can be very different depending on where students come from, and I think it's important to point that out. But I think one of the most important things that we can do at institutions is to point out to our students early on. So I do this within the first week, really, before classes start, that in addition to grades, they should not just focus on their academics, because a graduate program is so much more than that. And I think it's very important to outline to students the professional development and career building opportunities that our institutions offer, and to really encourage them to seek them out and to take advantage of them, even though they may be unfamiliar with them. I know I was. Because I came from a different system. So those are things like career development offices, where they can help students write their resumes and do mock interviews, and also explain what might be a different expectation for an interview with a US firm versus maybe a firm in the country where the student comes from. Also, I think professional training opportunities is very important to encourage students to seek those out, even if they don't provide credit or a grade, like international moot court. I think many of us have been involved in international moot court and know what a great professional training it is, but also what a phenomenal networking opportunity it can provide. And off the top of my head, I know at least a dozen people who received job offers through the connections that they made at moot court. So those kind of endeavors are very important. Also, I encourage my international students to seek out law review. That's something they would not normally think about, but we know that that can really be helpful to a student's career. Clinical work and externships and practicum placements are very important. Also, encouraging students to publish, to use that year of graduate study to maybe turn one or two of the papers that the students write in their studies into a publication, to kind of lay the groundwork for your future career. I think that's very important. And of course, to seek out arbitral organizations, young practitioner groups, but not just become a member and then kind of sit silently in the background. I think it's very important that we encourage students to seek out leadership positions, to seek out positions like being a case reporter or being a regional representative, so that the student's name is out there with their work product attached, and they can really start to build that those accomplishments. I also think it's an important way that graduate programs contribute to the field by allowing students with their peers to build their own network. And it's a network that I know that I still rely on, in fact, Harut and I went to law school together. I was an LLM student and he was in the JD program. And I think that is very important. And of course, the more diverse our graduate programs are, the more diverse will the networks be that our students are able to build. And then that, of course, also goes for the connections that our students forge with professors, which some of the full-time professors, the adjunct professors who are often top practitioner at the field, and of course, members of the legal community like externship or practicum supervisors. I think it's very important that we as an institution ensure that the professionals that are associated with our programs also reflect the diversity of the field. So we need to ensure that we have teaching staff from various backgrounds, from various regions. I think that that is very important for students to see themselves reflected in the legal community that they're trying to enter. And in that regard, I think it's also our responsibility to recognize and address unconscious bias that actually might exist within our student body, which is something that I also experience. So I think it's important that we encourage our students to attend events like these, where matters of diversity and inclusivity are discussed, so that when students leave our institutions, they can have a better awareness and a better understanding of the importance of these issues. So in short, I think that academic programs, they don't just lay the foundations, the academic foundations for entry into the practice, and sometimes there are entry requirements, and I think that's something that Mandy said as well. Sometimes an LLM is expected, but I think that more importantly, they can be the beginning for the students to build their own networks, to build out the mentorship relationships with established practitioners in the field, and to enhance their visibility and their reputation in the field. And I think that we can all contribute to making that a reality by mentoring students and by being present and by being available. I think that we can all contribute and give back.
Thank you. Thank you so much, Sandra. One thing I can vouch for is I very well remember that my first few days at the LLM program, one of the most important things that Sandra taught me, you have to learn how to network. You have to learn how to market yourself. You have to learn how to have conversation with these people. And we are going to provide you with the avenues, but you have to go out and get them. So I think that, as I think I can say that has really helped me. And but yes, one of the most important things again remains, significant investment and lack of return, especially if you're not, as Sandra pointed out, if you're not a US citizen, it's very difficult to have that education in the US because you don't get federal grants, you don't get the same even rate of interest that your counterparts in the US would otherwise get. But I think it's still a building process, and it's still going to take years. And again, going back to Mandy's statement that today's students are tomorrow's counsels and arbitrators. But also very important to talk about right now is what Mandy is doing with careers in arbitration. And I think I won't take much time explaining that. Mandy, I'll just hand it over to you.
Thank you very much, Ishan. I'm going to keep this section short and sweet without any further special guests, I promise. It's often said that knowledge is power, and it's certainly the case in international arbitration. Many of the people listening today will be based in a major arbitral seat, and you can normally, and I'm pretty confident you will again post-pandemic, be able to attend a plethora of arbitration events. You can build your network by meeting your colleagues over coffee, and you can learn about new opportunities organically. You're probably likely to feel part of the arbitration community, and your friends will tell you if their firms are recruiting, or your fellow students will tell you about the internships they've found or the publishing opportunities in a journal. But what if you're based or studying outside the major arbitral seats? What if you do not have any contacts in the legal field? You can't afford to travel to international or even domestic arbitration events. There might be no young practitioner group in your jurisdiction. Where do you find your mentors and sponsors? And where do you go to learn more about opportunities in the field so you can progress? Well, these were the challenges that some of my mentees across the globe were facing. And so last year I decided to try and do something about it. I created the Careers in Arbitration feed, which is on LinkedIn and Twitter. to quite simply make it a little bit easier for the best candidates, wherever they are based across the globe, to have access to good quality information about publishing opportunities, internship opportunities, events, speaking opportunities, leadership opportunities, and of course, substantial roles in the field of international arbitration. And this is based, of course, on the premise that law firms and other organizations want to find the best candidates. It shouldn't matter where they are in the world. If you are good enough, if you are the right fit for that particular role, you need to know about it so you can apply. If you don't know it's there, how are you possibly going to be able to apply for it? The reality is that most students and most practitioners are not going to have the time to scour the websites of the firms recommended by the leading directories on a daily basis to see if a vacancy happens to have popped up. Arbitration is also an unusual field because individuals are not normally simply looking for a role in New York or London or Paris. I have people who approach me saying, well, I'd be happy to work in, Portugal or Paris or, Germany or Latin America or New York or DC or Singapore. And it's very hard to find opportunities in all of those different jurisdictions. Arbitration is therefore an unusual market. So the starting point from my perspective was quite simply to try and make sure that information was available, because after all, knowledge is power. It shouldn't be limited by geographical location or whether or not you can sit down and have coffee with somebody in an arbitral seat in order to find out what's going on. So in the same way as events going virtual has helped to some extent level the playing field a little bit when it comes to gaining knowledge about our field and current developments, putting opportunities in one place that's accessible to anyone on LinkedIn and in the future, anyone on the internet who can access the website, helps, I hope, a little bit to level the informational playing field. And that is what careers in arbitration is all about. And that is all I'm going to say. So thank you very much.
Thank you, Mandy. Mandy said it twice, knowledge is power. And I think it's also important to know what happens in a tribunal. And Chris Campbell is often making that exercise quite fun. So I now invite Chris to please share about what the idea of Tales of Tribunal and how that's making arbitration and learning about arbitration more fun.
Well, thank you, Sean, and welcome to Tales of the, this this panel that we're doing. So thank you for that, and I'll keep my comments relatively short and to the point. They actually exist at the intersection of Mandy's and Sandra's comments. Someone recently pointed out to me that, and you kind of just hinted as well there, Sean, that I like to bring these sort of mainstream sort of ideas or things that don't currently exist in the field to arbitration for a pretty basic and pretty fundamental reason. Mainstream things are familiar and they're accessible. If we can make this practice more familiar, something that is shrouded in mystery and secret, international arbitration, if we can make that a little more accessible, a little bit more familiar, then that, I believe, can be the conduit and the road to how we make it something that anyone that wants to be involved in international arbitration can be. And that's frankly what we try and do in Tales of the Tribunal. I found myself going to a lot of these different conferences around the world, a lot of these different events, and I found that everyone I was talking to, invariably to a person, had these really interesting stories. I'd say, so when you're not doing arbitration stuff, how do you spend your time? And they'll say, oh, I teach flamingos how to do Brazilian jiu-jitsu. And there's these kind of things that were so just random. And I was like, these stories have to get out there. And I thought that if the speakers, if these senior people or these people just doing something in the field can be humanized, and that's what we try and do in the show by just letting them talk and tell their story, then it might make people that are looking to find their way into the field a little bit more traversable. And so, frankly, that's what I'd love to see next, into the future as we start to, come out of our working from home situations. I would love to see, more mainstream things in arbitration. Arbitration karaoke was something someone mentioned, that would be a fun event. Arbitration, some pickup games of basketball or football at the next V-Smoot. That'd be an awesome sort of thing to see. So we'll see what that looks like going forward. And I guess the final thing that I would say is to echo Mandy's points, and it's what some others have said. If we are not creating opportunities for people to really engage on a meaningful level, for them to feel comfortable talking about their situation, where they're headed, what they like to see, things that could be great for the community, then I think we're really doing a disservice not only to them, but ourselves. You know, ultimately, we're only as strong as our most vulnerable. And so by giving that opportunity to as many people as possible, I think that's what we can do. The final thing I would say, and I promise this is not just self-promotion. Tales of the Tribunal launched a new segment, Disputes Digest, where we're covering news and events from around the world of dispute resolution. If you have something, send it to us. We're on LinkedIn. Feel free to find us, and we'd love to cover the things that you're talking about. And thank you so much for facilitating this conversation.
Thank you so much, Chris. And I think we are kind of running out of time, and we really want to save 5-7 minutes so that we can actually take up the questions that a lot of our attendees have asked. So I'll quickly hand over to Kirsten to swiftly go through the last round.
Thank you very much. Now we will look forward and find recommendations and proposals to improve the situation. And with that, I would like to invite Catherine to share a few words about arbitrator intelligence in that respect. Catherine, please.
I'm not going to use the slides that I had prepared just so I can keep this shorter. But a lot of, we're at the point of the program where it's like, okay, we've reviewed what the problems are, what the challenges are, what the interests are, what can you do? Arbitrator intelligence has what I think is a relatively simple and straightforward formula that can allow everyone to actually do something. So I'm going to just give you a small example from LinkedIn this morning. An arbitrator from Nigeria named Dorothy Olfott was named the Arbitrator of the Year in Africa, which is really fantastic. But I'm betting that most people from outside of Africa have never heard of her. If you had a dispute as a lawyer and you wanted to appoint an African woman arbitrator, how would you go about, you've heard her name, you know she's acclaimed, but how would you go about deciding if she's the right arbitrator for your dispute? I think one of the most important things we can do is create independent informational resources, which is what arbitrator intelligence does. We started actually in Latin America because of our relationships there that allowed us to generate a lot of information and data on Latin American arbitrators. I love that when I go out and I present our sample reports, I say I'm promoting diversity in real time, because no one has ever heard of these preeminent Latin American arbitrators who are rock stars in their jurisdictions and their regions, but are virtually unknown outside. So on LinkedIn today, I suggested if we see Dorothy Olfott named as one of the leading female arbitrators in Africa, but she's not known outside, if you've had an arbitration with her as an arbitrator recently, take a few minutes out, go to our website and fill out an AIQ, an arbitrator intelligence questionnaire on her. Then we would have data, so we could create reports on her so that people who are interested in appointing more diverse arbitrators can look meaningfully at her track record and decide if she's the right arbitrator for their dispute. I'm done.
Thank you very much, Catherine. And Professor Shaughnessy, if you could share a few words about the inclusiveness report that is in progress, we'd be grateful.
Well, I really can't because I'm not on that task force. So I don't have any news, but I guess you can go to the ICA website and find out who is on the task force and perhaps check and see where they're at with the report.
Yeah. And Professor, do you have any advice on how institutions can help in paving the way forward with this?
I'm sorry, to help with the what?
To help pave the way forward.
Good. Yes, institutions have taken a leading role. And as I said originally, the fact that we see institutions' performance really having improved markedly in the last few years is a sign that making conscious, or as Rose says, intentional efforts do pay dividends. And but we need that to not just be the institutes paving the way. We need all the stakeholders to get involved, because we still see that party appointments of diverse arbitrators is really lagging behind. And so the institutions may be paving the way and getting some, lowering the barriers to entry, but much, much more needs to be done. And it needs to be done by all stakeholders. And I think I saw in the chat that there was a comment by a Swedish GC, Eric Dominus, about the line of command. I wondered if Christopher saw that, saying everyone says parties should start demanding diversity on their teams and in the appointments. And that's going to cause the firms to start promoting women and bringing them up. And I think Eric pointed out, it's not that easy for the GC to simply say, we want a diverse person. I don't know if you saw that, Chris, the comment by Eric about the chain of command and having to push this at every level within the company.
I didn't see that comment specifically, but I mean, it's true. I mean, while we don't necessarily have that unilateral ability, it absolutely is a factor, and it's certainly something that I think for engaged GCs is something that, or in-house counsels, has to be on the forefront of their minds before lawyers will, in a whiplash sort of effect, respond to it.
Well, thank you so much. There is one interesting question that came up in the Q&A. I just want to invite Rose to help share some views on this. So what role for diversity will be played by the roster of arbitrators of African descent that was addressed recently on OGMID by Professors Ben Davis and Catherine Simpson? If you could share in a minute or two what your views are.
Thank you, Kristen. I think you also forgot you had added a comment about inclusion because you had amended. So I'll address that in the last one. I think Professor Shaughnessy mentioned earlier that the ICA report was very Eurocentric and more to come with respect to the inclusion. And when we think about inclusion, I'd love to quote my friend, my colleague, Lucy Greenwood. And I think when I attended a talk that she gave, and she may have quoted somebody who said this, so I don't remember that person, so I'm going to quote her. She said this: diversity is when you invite me to the party. Inclusion is when you ask me to dance. That resonates with me so well, because when a law firm just hire people who look like me, I've had this experience. You go to the firm, okay, we meet the diversity, we have the Black person there. But if you don't give me the cases, so you did not include me. So you're actually crippling my mind. I'm sitting at your firm and not having the cases to work on. So that's a very interesting way to think about inclusion. Going back to this wonderful list, so what? It's there. How is this going to benefit us? I would say, unless the law firms, and going back to what the GC from Sweden says, unless the clients and the law firm, they're going to be intentional to say, we want the group to look like us today. We want more diversity. Where is the Latin American people? Where are the Asians? Where are the Blacks? And mind you, in Europe, for instance, when they just go and appoint an arbitrator from Africa, they may think they have resolved diversity. In reality, they have not, because you have the African American arbitrators. Although they shouldn't be called African Americans, they should just be called American arbitrators. But unfortunately, this is how it is. They are African American. How are we going to make sure that they are appointed? Let's be more inclusive. Let's find ways. Let's be intentional in our appointment, in our system. And I know it's very hard, and that could be a sequel, a next discussion. Chris can take on that one. But it must be done. We must do it. We must be intentional. We must include. And that's the only way forward, so we can have this panel looking like this, just like I presented with common law and civil law, where they do a compromise. That's what we need to see in international arbitration. Because without Black people in international arbitration, like Howard mentioned earlier, you have most of the cases coming out of Latin America and Africa, then we can't call it international arbitration. That's my last word.
Thank you very much, Rose. We hope to continue the conversation. This is just the beginning, and I want to thank Professor Rogers, Professor Shaughnessy, and Rose. Thank you so much. I now hand it over to Ishan.
Oh, thank you so much. I think we covered a lot of ground here. I think a lot of ground, and I think this can set the tone for many more events like this, where we can actually isolate those issues and have those discussions in much more detail. We have a lot of questions that have come in, but I see that it's almost past time. So what we can do is request our attendees to stay on for about 5-7 minutes more, and we can quickly go through some questions. One important question that I find quite interesting is, how will increased diversity in international arbitration affect the leading seats of arbitration selected by parties or their counsel? Anyone would want to take that up? Professor Shaughnessy.
It's going to make the Arbitration Institute much greater, have much greater attraction. And we'll see, I think Kevin Nash at SEAC has said it well. He said that when the appointments of arbitrators in our institute do not reflect our users, we have a problem. And when an institute's users are reflected in their appointments and are reflected not just in arbitrator appointments, but in events that they organize, that people who are brought to stage, people who are brought to rules committees, people who are brought to task force reflect the users that they're serving, then that institute is going to grow its cases and grow its users. So I think that an institute that doesn't actively engage at all kinds of levels in their internship programs and their seminar programs and their mentor at every level, they are undermining their own market share.
Yeah, and if I can add, just Ishan, that's exactly the point. This is a market dynamic, right? People select institutions, they select seats. Now, at the end of the day, all of this speaks as well to people's confidence in those institutions, in those seats, which is a multifaceted sort of analysis. And if the seat, frankly, is unable to compete in a variety of ways, including this, they will not be competitive. And the same is true of the various seats that are the principal seats that people look to for these. I think ultimately that is, to a very large degree, a question of not only the practical ability of the seat to host an arbitration and ultimately be the legal source of its authority, but also ultimately the party's confidence in selecting these kinds of places or institutions to resolve their disputes.
And if I may just share quickly this result that came out about legitimacy, I think you can all see it on your screen. That do you think lack of diversity affects or can affect legitimacy of proceedings? 63% believe yes, it creates a conscious and unconscious bias, but 33% believe that no, there's no bias, but diversity will still be better. I think if we have a couple of minutes, can we just, in a bit of detail, discuss about bias overall, conscious and unconscious bias? Professor Rogers, if you would like to comment on that, please.
Sure. So in terms of unconscious bias, I mean, for those of you who, it's a very loaded term that if you haven't studied it specifically, you might not necessarily understand what it means. So we all think we understand what the word bias means. It means that you're prejudiced, right? But a lot of us don't think of ourselves as prejudiced. The notion of unconscious bias has been developed by neuroscientists, psychologists, sociologists, and what they measure with that term is the effects of ways of thinking and modes of thinking that not consciously but unconsciously incorporate some assumptions we have. And many of those assumptions, and there are actually tons of different categories and types of unconscious bias, but a number of them do have to do with how people look or what their backgrounds are. And so one example is, and it can interfere with people's actual progress. So one very famous research study was of, I think it was violinists or cellists who were never selected to be in an orchestra. They had like a almost perfect rate of unselecting women for these roles until they put up a screen. And so that the performers were evaluated only on how their playing sounded, and the people selecting them had no idea what gender they were. There's been something like that talked about in international arbitration. I'm more skeptical about how it really works or would work, but called blind appointments. But certainly one of the ideas and a number of the initiatives, including by Lucy Greenwood and others, is to make us all more aware of our unconscious biases. And one of the things that's being debated in the United States right now, which I think is important to say out loud, is we all have these. It's not, I actually think it's a little too simple to say, well, I'm not racist, this other person is racist, because what it does is absolves us of having to look more deeply into our motivations. Because I think the reality is we're all, racist is such an ugly word, but we're all biased. We all have biases, and they come in at different times in our lives. They come in different contexts. But to say that you're sort of free from bias, you're kidding yourself. And so I think one of the things that we can do is all work hard to check our own biases, work hard to check when the collective biases of our colleagues end up institutionalizing some of that bias. For example, in panels that are no longer, that are composed of all, like panels like this, which is very diverse, and Rose talked about the intentionality of putting this together. Intentionality is a way of counteracting unconscious bias, meaning the bias that creeps in when we aren't being intentional. So I actually, I don't know if we're all the way at the end, but I want to congratulate everyone on this tribunal for thinking about and talking about a lot of both hard and inspirational issues. The fact that we're even having this conversation, I think, really raises the quality of the dialogue. I've been on a number of panels about diversity. This has been one of the most, I think, well-rounded in terms of different approaches and topics. A really great group of people covering, I think, an expanded idea of what diversity is. It includes, not only gender, nationality, ethnic background, but also subcategories of cultures within a particular country. It involves socioeconomic backgrounds. It involves very much access, related to socioeconomic access to education and the kind of mentoring that's necessary for your career to advance. So thank you all for having me and for such a thoughtful and engaging discussion on these very important topics.
Thank you so much, Professor Rogers. I think you hit the nail in the head when you said that we are all biased somewhere or the other. And I think it's an ongoing process that we have to keep a check on ourselves at every level, because I believe all of us somewhere or the other are influencing others and also the way they look at arbitration. So I think there's, again, a long road ahead, and I think all of us can do a lot. And those who've attended too, we can, even if we understand and accept the fact that we have to challenge those biases first by checking on those biases within ourselves, I think we are going to do a great deal of good. And I personally would thank all of you, each and every one of you. I think it's been a fantastic panel, a fantastic discussion. There has been a lot of quality. I would say, every moment of the discussion here was a lot of quality, and including all the attendees who asked some fantastic questions. And the chat here was like, it was amazing. I can't just say how happy I am to read the entire chat and all the comments that have come in. So in fact, I'll just open the floor to everyone to just say whatever you want to.
Ishan, I wanted to add something on what Professor Rogers mentioned from a practical standpoint. I've been engaged in cases where you have a situation in Africa, for instance, in Ghana, my example, where there is no streets names, right? And now that we have streets named, but back then when I moved there, 2014, there was no streets names. And you're going before the tribunal, and there was an issue as to whether or not a piece of mail was delivered. This tribunal, if they don't know anything about Ghana, they've never traveled to Ghana, they have all they know is just like, okay, maybe African people, there is some kind of fraud issue. And this bias in the back of the tribunal's head could be very damaging to determining whether or not someone is telling the truth. And what I find is that, and in presenting the evidence, I was there at the university. I know when I deliver a mail, I need to have a runner, a boy or a girl, somebody, to go to the Ministry of Justice, whatever, and presented 2 letters. One, the original letter, a second one that they will open and stamp and date and time and bring it back to me. In shuffling, if that letter is lost, and in the future I'm saying to the tribunal, I did mail that letter, and they say, no, we never received it, I have no proof. And it's very important for the tribunal to understand, just because I can prove it doesn't mean it really didn't happen. Doesn't mean you have to automatically thinking that, well, these African folks, maybe it's all fraud, or maybe, and there is this bias there. And as Professor Rogers says, if we just go consciously and say, well, you know what? Well, let's think about this as Alcohol Anonymous. My name is Rose Ramo and I'm biased. Please help me. So you go into it thinking that you have your own bias, and you're going to be intentional by trying not to be biased. And I think that's the way to resolve a lot of issues before the tribunal, because you will find them. And it doesn't mean that they are bad arbitrators. I don't think that means that they are racist or anything. It's just like, this is what you see all the time, and you're thinking perhaps that's the truth. Like recently we have the case with PNID, which was decided against Nigeria, $9.6 billion. And then now the High Court in England says, well, there was fraud in it. So all arbitrators and practitioners, we're reading this, are like, oh my God, $9.6 billion. I wonder what happened. Now, maybe when you are appointed on the case for Nigeria now, you have to think, well, you know what? Maybe I'm a little biased. Let me just step back and really not thinking that all Nigerians will be doing this. Let me just be honest here. Oh, that's it.
Great. So before we part ways, I would first request all of you to just, give a big best smile of yours. I really love taking screenshots. So I think on the count of 3, 2, 1. I think that was great. And any closing comments, Mandy? Mandy, I think you are leading the way for a lot of youngsters, especially in the times of the pandemic, where suddenly everyone is now opening their eyes to the world of arbitration and reading and writing a lot about it, and you're leading the way. I think just one final comment from your side. You're on mute.
I always do it at least once during a webinar. Ishan, you are, as always, too kind, so thank you very much for the kind words. When it comes to the diversity debate, the important thing is that we keep talking about it. In the same way as unconscious biases become conscious biases once you become aware that you have them, and therefore you can act to try and mitigate against those biases. If we keep talking about diversity, if we keep talking about inclusion, if we keep talking about representation and how we as a community can make things better and more inclusive and more diverse, then at least we're doing something. At least we're being active. It's being passive. It's when you sit back and you don't do anything and go, hey, you know what? It's someone else's problem. Somebody else will sort out diversity. Somebody else will sort out the lack of inclusion in this particular area. That's when we become complacent. So I'm really pleased and proud to have been able to participate in this really engaging panel today. And I'm very grateful to you all for sharing all of your fantastic insights from different perspectives from all over the world. So thank you. Thank you all. And thank you all very much for listening as well.
Thank you much, everyone on the panel, and to all who are viewing right now. I just want to say that together we can make some difference to the current landscape. And it's only when we work together that we can do some change for the better. Just want to thank you all for joining us today.
Thank you, everyone. Bye-bye.
Bye-bye.